Madam Kuto to take over.
A very good evening to Honorable Justice B.B. Nagarathna, Honorable Judges of the High Court of Bombay at Goa, dignitaries, ladies and gentlemen. A warm welcome to Salgaocar College of Law, the college which has made a mark not just locally but nationally and internationally. Our lamp has been kindled by a spark from our founder, late Sri V.M. Salgaocar. And the light of this lamp has been made bright and radiant with our President of the Education Society, Mr. Dattaraj Salgaocar, and other members of the Governing Council and of the Managing Committee. It is said, a journey of 1,000 miles begins with a single step. That single step was taken on 27 June 1973, when our beloved founder, late Sri V.M. Salgaocar, established the first law college in the state of Goa at the Lyceum complex in Altino, Panjim. The establishment of the college brought to fruition the dreams and aspirations of many in Goa who wanted to take up a career in law and would otherwise find it difficult because they had to go to neighboring states to pursue their legal education. This is the formal inauguration of the college in 1973. This is the teaching staff picture of the college during 1973, at the time of the inception of the college. And I'm happy to tell you that there is also a moot court in session. At that time, even legal education was taken seriously. Keen to provide law students with better and more facilities, our founder decided to construct a new campus at majestic Miramar in 1980, within a short span of 7 years. And this is presently where the college is now. So during the inception of the college, we started out with a 3-year LLB program. In 1998, we had added 2 courses. One, we have the 5-year LLB honors course, and we also introduced the LLM program. In 2006, we were recognized as a research center. So far, we have awarded 26 PhDs to research scholars. 22 are ongoing. And in 2012, we have the 5 years integrated BA LLB program, which is a double degree program. And in 2023, we have all of these 4 programs running. This is just a timeline of all the important milestones the college has reached. Let me just say that in 1973, our founder named the college after his late father, Mahadev Rao Salgaocar. And in 1998, the college was renamed to VM Salgaocar. Our college has 18 classrooms, fitted with smart boards, ICT enabled, and AC. We have a dedicated moot court room, research room, and cyber lab, as well as a book bank room. In 2005, the management got constructed a special library building, 3-storied building, which has a vast collection of books, more than 35,000 odd books and e-resources, and it is named after named Srimati Hirabai Vasudev Salgaocar Library. It is an annex to the main building of the college. To make sure that there is holistic development of law students, we have sports facilities outdoors arranged and also an indoor gymnasium. Within the classroom, teachers supplement the lecture method by introducing students to various clinical methods of teaching. They make use of simulation exercises, trial advocacy. They encourage membership in the clinics. Presently, our law college has all these clinics, the child health clinic, and with the participation in the child rights clinic, for example, we have students coming closer and understanding the procedures followed in the Children's Court and the Juvenile Justice Board. They're able to facilitate access to justice for children who come in contact with the justice system. Similarly, the consumer clinic of the college has settled and resolved 26 consumer cases, and so also with the other centers. Each of them have taken remarkable steps. The college also runs a number of certificate courses to enhance knowledge, capabilities, and skill development. Some of these are here. Certificate course on maritime law, on conveyancing, on criminal procedure, all that would help in the legal profession. I'm happy to say that, encouraged by a very supportive management, a very resourceful principal, VMS faculty then and now has, through their expertise, their experience, their research ability, their writing skills, their mentoring skills, guidance, creativity, talent, and innovation, made sure that the college has achieved heights of excellence, whether in academics, sports, cultural activities, moot court, ADR, and legal aid. In academics, we have many of our students getting the gold medals and many of our faculty members being awarded the PhD. In sports also, we have number of achievements. These are the laurels won by our students. The girls are not to be kept behind. We have, at the recently concluded National Games, 2 of our students winning gold medals. In moot courts, our college has participated at the international moot court competitions organized abroad. They have also won various national moot court competitions around in the country. Here are a few glimpses of the laurels won by the students. In mediation, the college, once a runner-up in 2017, has gone on a winning streak. Thereafter, winning the mediation and negotiation competition in 2019, and then in 2022 at Poland. Our college has fared remarkably well at the Students' Parliament, winning 2 consecutive times the first place at the Students' Parliament organized by the Goa Legislative Assembly. We are hoping to make it a hat trick by winning the next one, which is now close at hand. About legal aid, I just want to place on record that this is the first college in India to have a comprehensive legal aid program consistently sustained for the last 25 years with the active involvement of the faculty and the students. Right now we have the Legal Aid Society, which is looking after and operating 27 legal aid cells, which are spread across the length and breadth of Goa. Some of the glimpses of legal aid done by VMS students, where they have tried to stop child labor happening in the shacks on the beaches. Various other capacity building drives, creating awareness, improving the midday meal project, engaging with the community at a one-to-one level, having by the medium of street plays. They have even gone to translate the RTI Act into Konkani so that it is more useful to the members of the public. We can just see there the achievements of our legal aid cells. We find that we have filed 24 public interest litigations so far. So many senior citizen cards have been done by our students, Krishi cards, other entitlement cards like ration cards, etc. And more than 100 legal awareness programs are done every year. And for all these efforts of the college, which have been recognized, the college has been awarded a number of awards. We have got, first of all, the Institutional Excellence Award. Thereafter, we have a number of awards for legal aid. The Knowledge Tees Award, the Herbert Smith Free Hills Community Engagement Award, and the rest. Our success stories. Let me tell you that at the International Conference on Legal Education and Ethics in 2008, our college legal aid program was suggested to be a model for the other American law schools. Legal aid at Salgaocar Law College was suggested as an alternative model at American law schools. Tremendous achievement. And similarly, we were also granted a research project by the UNDP. VMS has always been a trendsetter and a trailblazer. We started out organizing the Bar Council Moot Court competition. We went on to organize national moot court competitions here in the college. We had the Law Fest and Lex Novitas programs. And we have now gone on to conducting international dispute resolution program competitions. Our alumni have always supported us in all of these endeavors. A few glimpses of Lex Infinitum, which was conducted in the previous years. We are now gearing up for the 9th edition of Lex Infinitum. Our students have been winners all the way. I'm happy to say that many foreign universities have MOUs with our college. We have an MOU with the University of New South Wales, Sydney, Australia, where they came here to our college to study the child rights clinic and how it functions. We also have MOU with Lisbon University. A number of green initiatives which are there at towards the back side of the college. What a rewarding experience it is to tell about the alumni of our college, some of them who are sitting here in this August gathering. We have our sitting judges who are alumni of the college. There's a former retired High Court judge who was also an alumnus of the college. We have our Advocate General, many senior advocates, other advocates, public prosecutors, all who belong to VMS. And we also have many in the civil service. We also have the first of its kind VMS Incubation Center for Advocates, which helps and is a support system for law graduates, alumnus of the college who have just graduated after completing their law studies, and they are given help with office premises. Thanks to our management for this great initiative. And now the road ahead. We have a new campus. We are shifting to a new campus in some time, and this campus is going to be a sprawling campus. It's going to be located at Old Goa. This was the foundation stone ceremony on the picture. So having said about all the milestones, I can just say that we are moving towards excellence. The journey towards excellence continues. And the Golden Jubilee celebrations start with today's program. And then we are looking forward to establishing the Center for Research, Innovation and Analysis. And we are going to have a series of law lectures, Infinite 19. Thank you all for your patient listening.
Thank you, Madam Kuto. Wish and pray that our journey towards excellence continue. We shall commence with today's formal program by lighting the lamp of knowledge and wisdom. I humbly invite the esteemed dignitaries, Honorable Mrs. Justice B.V. Nagarathna, Honorable Shri Justice Mahesh S. Sonak, Honorable Shri Justice B.P. Deshpande, Honorable Shri Justice Valmiki Samlezis, Professor Dr. Venkata Rao, Mr. Dattaraj Salgaocar, Mrs. Deepti Salgaocar, and Principal Dr. Shabir Ali Ji for marking the auspicious beginning of today's program. Deepest appreciation for the students of VMSCL Law College for their gifted performance. Thank you. I now invite Mr. Dattaraj Salgaocar, President, Governing Council, Devi Sharwani Education Society, to address the forum.
Chief guest of today's function, Honorable Justice B.V. Nagarathna, Justice Mahesh Sonak, Justice Menezes, Justice Deshpande, Professor Shabir Ali, members of the faculty, esteemed members of the legal fraternity, teachers, alumni, honored guests, ladies and gentlemen. It is with great pleasure and a profound sense of pride that I warmly welcome you all to this momentous occasion as we celebrate the 50th year of our esteemed Law College. As President of the society that manages Salgaocar College of Law, it is a privilege to stand before you and share in the joy that this milestone brings. Today, we have the distinct honor of hosting a remarkable person, Justice Nagarathna, a towering figure in the legal domain and a distinguished lady judge in the Supreme Court of India. Her contributions to the judiciary and outstanding judgments have not only set new precedents, but have also inspired countless individuals, particularly aspiring lawyers and law students. As we gather here today, we are reminded of the importance of nurturing legal education in an environment that encourages intellectual growth, diversity, and excellence. The college was started by my father, late Mr. Salgaocar, as Goa had no law college at that time. And his thing was, we should bring a lot of things into Goa so that the Goans can benefit and it can be a center of excellence all over India. The role our law college has played in the last 50 years in shaping the minds of future legal luminaries cannot be overstated, and it is a responsibility that we hold dearest to our hearts with utter reverence. Over the last 5 decades, our institution has been a beacon of legal scholarship, producing graduates who have gone on to make significant contributions in the realms of law, justice, and advocacy. We have strived to instill in our students not only a profound understanding of the theoretical underpinnings of law, but also a deep sense of ethics, responsibility, and commitment to serving the cause of justice. We have initiated various activities, as Professor Kim Kuto has shown, Legal Aid Cell, Child Rights Clinic, Lex Infinitum, and many others to instill holistic and practical legal knowledge to our students. As we reflect on the journey that has brought us to this moment, we recognize that our success is not merely the result of academic rigor or institutional prestige. It is a testament to the unwavering dedication of our faculty, past and present, the diligence of our students, and the support of our alumni and well-wishers. It is indeed a collective achievement that we celebrate today, and I convey my heartfelt gratitude to all of them. Justice Nagarathna, your presence here today serves as a source of inspiration for all of us, and we thank you very much for your presence here. Your illustrious career, marked by a commitment to upholding the principle of justice, and your pioneering judgments, stands as a testament to the transformative power of law. As an institution dedicated to nurturing the next generation of legal minds, we are indeed deeply honored to have you grace this occasion with your presence. It is also important to acknowledge the pivotal role women have played in shaping the legal landscape of our country. From breaking barriers to championing causes of gender equality and social justice, women have been at the forefront of legal advocacy, often spearheading transformative change. We take this opportunity at our law college to reaffirm our commitment to fostering an inclusive environment that empowers and encourages aspiring female legal professionals to excel and lead. Once again, I extend my heartfelt gratitude to each and every individual who has contributed to the success and legacy of our law college. Let us continue to uphold the ideals of justice, integrity, and knowledge as we embark on the next chapter of our journey, committed to shaping the future of law and nurturing the legal leaders of tomorrow. Thank you very much.
Thank you, sir. We are privileged by the esteemed presence of Honorable Shri Justice Mahesh Sonak. Your Lordship is known for his humble and soft-spoken nature, with a great acumen of law and loyalty to justice. Honorable Shri Justice Mahesh Sonak had a bright student career and has been one of the topmost advocates of Goa, practicing for the last 25 years. An additional standing counsel for the central government, well recognized for successfully fighting public interest litigations, an activist fighting for students' rights, and also spared time to espouse the causes of the poor and deprived. Honorable Shri Justice Mahesh Sonak accepted the momentous responsibility as judge of the High Court of Judicature at Bombay in the year 2013. It's a proud feeling to express that your Lordship is an alumnus of this institution. I request your Lordship to address the congregation with your words of wisdom.
Honorable Justice V.V. Nagarathna ji, my esteemed brothers, Justice Bharat Deshpande, Justice Valmiki Menezes, President of the Managing Committee, Mr. Dattaraj Salgaocar, Vice President, Mrs. Salgaocar, the Vice Chancellor, Mr. Rao, President Jilman Koel Pereira, advocates, senior advocates present here, Principal Shabir Ali, professors, staff members of my alma mater, dear students and dear friends. There are at least 3 reasons why I consider this as an extremely momentous occasion. First, this institution has completed 50 glorious years. Today we mark the beginning of the series of year-long celebrations planned to commemorate this important milestone. Second, as my alma mater, I associate this institution with lots of invaluable memories and I do get nostalgic. Therefore, naturally, it is a wonderful experience to return to college. Returning to such a place and recalling that those were the times always cheers one's spirit. Thirdly, and most importantly, the presence of Honorable Justice Nagarathna ji in our midst is a matter of joy and pride to all of us. Justice Nagarathna ji is an icon in her own right. She has achieved much and she is destined to make history very shortly. So her presence here today is an inspiration to all of us. Justice Nagarathna ji, we cannot thank you enough for coming here and flagging off the 50th celebrations of this institution. Thank you very much. Friends, today we felicitate Justice Nagarathna ji. We admire her achievements, rejoice in her achievements, because her achievements mark an important milestone in the women's struggle to get a foothold in the legal profession and eventually in judiciary. Bluntly, I would say that men should hang their heads in shame because we forced women to struggle and fight for what was theirs in the first place. But then women can stand tall with their heads held high because despite all the odds, they are on the winning path. Regrettably, we cannot say that the struggle is over. This struggle, according to me, should not be over until we men make amends, change our mindset, shun the stereotyping and gender pigeonholing. This is no longer a struggle between men and women. This is a struggle in which men and women must jointly fight to overcome certain attitudes in certain quarters that still need to be struggled with and ultimately defeated. Friends, in the 17th century, William Shakespeare described Portia's genius at advocacy in The Merchant of Venice. Undoubtedly, Portia's intelligence, wit, logical reasoning, art of advocacy were masterfully depicted by the great bard. But the unfortunate part was that Shakespeare had to masquerade Portia as a man before she could pass off as a Daniel come to judgment. Society, whose perspectives the bard reflected, was completely unprepared to concede genius in advocacy to an intelligent, witty, and rational woman like Portia. One could argue that all this was 17th century fiction. But what about the 18th, 19th, 20th century facts, both in the United Kingdom as well as the United States of America? In the UK, they had no problem with being ruled over by a queen. But there were all kinds of arguments to deny women the right to vote or to even enter into the legal profession. For a long time, the English law regarded women as chattel. In the US, the position was no better. In 1869, and allow me to refer to her, in 1869, Belva Lockwood, a courageous mother of two, applied for admission to the Georgetown Law School in Washington, D.C. At that time, she was 39. Her application was rejected by the college. She was told that her presence in the college would distract the attention of the young men in the class. Belva was forced to fight and fight hard until she was admitted to this law school. After she completed her degree course, the law school refused to give her the law degree. Young men in her class were cited as the cause for this strange and unfortunate approach. Graduating with women, it was feared, would lessen the value of men's degrees. So look at the degree of discrimination and even humiliation that Belva was condemned to suffer to get what she had earned through the dint of her hard work and intelligence. When all appeals to the university and the state authorities failed, Belva Lockwood petitioned President Ulysses Grant demanding her degree. She did not make a request. She said that I am entitled to it. Fortunately, at the president's intervention, the law school yielded, and the vice chancellor most reluctantly and most secretively awarded Belva Lockwood the degree that she had rightfully earned. Belva Lockwood practiced in the District of Columbia courts for 3 years before qualifying herself to practice before the US Supreme Court. In 1876, she applied for admission to the bar. At that time, such applications had to be placed before all the 9 judges of the Supreme Court. By a majority of 6-3, the US Supreme Court denied her application with a very terse explanation. They said, the uniform practice of the court and by the fair construction of its rules, none but men are permitted to appear before this court as attorneys and counselors. In fact, 3 years earlier, in 1873, the US Supreme Court, in the case of Bradwell versus Illinois, had already upheld a state legislation to exclude women from the practice of law. And Justice Bradley, writing the majority opinion, relied upon his understanding of the divine law rather than the constitution that he had sworn to uphold. And he wrote, the natural and proper timidity and delicacy which belongs to the female sex evidently unfits it for many occupations of civil life. Women's domain does not extend beyond the domestic sphere. Women's paramount destiny and mission are to fulfill the benign offices of wife and mother. This is the law of the Creator. Undaunted, Belva Lockwood lobbied the US Congress. Ultimately, in 1879, the Congress passed a law declaring that any women possessing necessary qualifications should be admitted to practice before the US Supreme Court. So at least insofar as the federal courts or the US Supreme Court was concerned, no woman possessing the necessary qualifications could be denied the right to practice. But the judicial opinion in Bradwell versus Illinois remained. At least the judiciary did not buy the arguments of discrimination, illogicality, or irrationality. Friends, just like the preamble to our Constitution, the US Constitution also begins with the hallowed phrase, "We the people." However, at least in the US for a very long time, this phrase did not include, or rather it was interpreted as not to include, women, blacks, or even the native Indians. Except for men, no one else had the suffrage. To the rest were apportioned only sufferings and humiliations. Belva Lockwood demanded something more than mere suffrage. She demanded full civil and political rights for women. Though she could not vote at the presidential elections, she twice ran for the presidential office herself. She successfully argued that nothing in the constitution barred a woman's candidacy. Mind you, she took this step almost 130 years before Hillary Clinton, who was incidentally the first woman candidate to run for presidency of the United States of America. Belva Lockwood said, and I quote, "We shall never have rights until we take them, nor equal respect until we command it." Belva Lockwood's words still ring and should continue to ring until discrimination is abolished in all spheres. Her words must ring until dignity and mutual respect become the firm foundation of gender relations in public and private spaces. Friends, it would not be wrong to lay the lessons of the past before the future, because those who forget history are condemned to suffer its repetition. Therefore, we must be on the constant guard against backsliding and ensure that our daughters and our granddaughters aspire and achieve all that which they are legitimately entitled to, without any illogical prejudices and artificial barriers. Friends, statistics about women's participation, particularly at the higher judicial levels, are quite dismal, not just in our country but the world over. Any discourse on equal rights and opportunities is often drowned more by the numerical majorities and loud voices of the opponents than by force of logic or rationality. At a stage when 3 out of the 9 judges of the US Supreme Court were women, the indomitable Ruth Bader Ginsburg was asked, "When will there be enough?" And she answered, "When there will be 9. She writes that the people were shocked. People called her most unreasonable. But Ruth Bader Ginsburg pointed out that there have mostly been 9 men and nobody has even raised any question about that. I am a great admirer of Ruth Bader Ginsburg. Her passing was a setback. Personally, after reading the majority opinion in Dobbs' case, in which Roe versus Wade was overturned, I quite mourn the ruthless Supreme Court of United States of America. The struggle to allow full opportunities to women in our country was by no means less hard or any more complete. Maybe the legal provisions as they stand or as they are interpreted may offer no significant barriers. Still, societal attitudes, societal expectations, and stereotyping of genders conspire against the idea or the ideal of equal opportunities. Judicial statistics, at least up to the level of district judiciary, may appear to be promising. But then serious thought process is necessary to analyze why the same is not translated into increased numbers at the High Court and the Supreme Court levels. If this difficult background is borne in mind, you will see why I regard Justice Nagarathna ji's ascent as a significant milestone in our judicial history. So today is the occasion to rejoice at Justice Nagarathna's stupendous achievements. She is not an icon just because of what she has already achieved or because of what she is about to achieve, but she is an icon because of the manner in which she has achieved all this. Justice Nagarathna has intelligence enough to succeed without any industry, and industry enough to succeed without any intelligence. But fortunately, God and the good wishes of her illustrious parents have blessed her with both intelligence and industry in abundance. I must share with you, with your permission, that even when she was here in Goa since yesterday, she has been busy dictating her judgments and not wasted a single moment. So that is the kind of dedication and that is the kind of commitment. Justice Nagarathna ji embodies the Sanskrit adage, Vidya Vinayena Shobhate, Notwithstanding the heights that she has achieved, she is an extremely down-to-earth person. She has displayed exceptional courage and sensitivity in her judicial decision-making. Some examples are her bold dissent in the demonetization case, or her steadfast commitment to protecting women's reproductive autonomy. A dissent in a court of last resort is an appeal to the brooding spirit of law, to the intelligence of a future day when a later decision may possibly correct the error into which the dissenting judge believes the court to have been betrayed. Memorable words from a great American judge, Charles Evan Hughes. Justice H.R. Khanna made these works even more memorable in his stirring dissent in ADM Jabalpur. As a judge of the Karnataka High Court, Justice Nagarathna ji declared that a child has no role to play in her birth. So there could be illegitimate parents, but there can never be illegitimate children. This was the sensitivity and the felicity of language at its best. Friends, it is a folly to keep on quoting Justice Nagarathna when she is here in person, and we are all extremely eager to be enlightened by her talk. I seek forgiveness if I have encroached upon your time and your patience. But I will not continue with my folly any longer. I conclude by wishing the college management, headed by Mr. Dattaraj Salgaocar, all the very best. I urge the students of this college to take encouragement and inspiration from Justice Nagarathna and work hard, not just dream to scale new heights. Work for it. Everything is possible, but you must believe it is possible and work hard to make it possible. I express my profound gratitude to Justice Nagarathna for blessing this occasion with her presence. I also thank each one of you for your patience and understanding. Thank you very much, and Jai Hind.
Thank you, Your Lordship, for sharing your insightful thoughts, especially on eliminating gender discrimination. We are fortunate and graced by the distinguished presence of Honorable Mrs. Justice B.V. Nagarathna, Judge, Supreme Court of India. Honorable Mrs. Justice B.V. Nagarathna is an exemplary legal luminary with a great acumen for law and was born in Bengaluru. Aiming for a dedicated career, her ladyship earned BA Honours in History from Jesus and Mary College, Delhi University in 1984, followed by LLB degree from Campus Law Center, Delhi University in 1987. In a span of 7 years, her ladyship embarked to establish independent practice and also has represented Karnataka State Legal Services Authority and High Court Legal Services Committee. The year of 2008 witnessed a fundamental turn in the illustrious career of her ladyship as an additional judge of the Karnataka High Court, subsequently becoming a permanent judge in 2010. A noteworthy, momentous position which carved a place in history as the first woman from the Karnataka bar to ascend to the High Court, breaking barriers and inspiration for masses. Honorable Mrs. Justice B.V. Nagarathna has played a pivotal role by serving as the president of the Karnataka Judicial Academy and the Bangalore Mediation Center, Bengaluru, during her leadership's tenure in the Karnataka High Court. Her leadership's commitment to the legal fraternity extended beyond the courtroom, contributing significantly to the book Courts of India brought out by the Supreme Court. Her leadership served as the chairperson of the committee, spearheading the translation of this book into Kannada, furthering accessibility and knowledge dissemination. In a momentous stride, Honorable Mrs. Justice B.V. Nagarathna was elevated as the judge of the Supreme Court of India on 31st of August 2021, where her leadership's contributions continue to shape the legal landscape. Notably, her leadership serves as the chairperson of the Juvenile Justice and Child Welfare Committee, Supreme Court of India, with a dedicated approach towards fostering a more just and compassionate society. Additionally, her leadership is a member of the Supreme Court Gender Sensitization and Internal Compliance Committee, advocating for inclusivity and fairness within the judiciary. Her leadership's career stands as a testament to her unwavering commitment to justice, equality, and legal excellence. Deeply humbled and pleased to invite Honorable Mrs. Justice B.V. Nagarathna, our distinguished chief guest, a beacon of inspiration for generations to come, for a formal address. Ma'am.
Namaskar and a very good evening to everybody. At the outset, I am really happy, I must say, to be frank, about the overwhelming references made to me. I really do not know whether I deserve all that. Both the chairperson of the governing council of this institution and Justice Sonak have been really generous in showering praises on me. This only makes me more focused because I should continue to do so and not be just, you see, be flattered in the sense of saying that I am great. So at the beginning, I must say I am not at all great. I don't know whether I deserve all this, but anyway, I accept it with all humility. So with that, I must say that I am, first of all, address the honorable judges who are present here, Justice M.S. Sonak, Justice Bharat Deshpande and Justice Valmiki Menezes, judges of the Bombay High Court at Goa. Then Mr. Dattaraj V. Salgaocar, Mrs. Salgaocar and his family, the management and governing council of the college, Shri Professor Venkat Rao, Professor Yashomati Ghosh, whom I know from the NLS days, Shri Gilman Kulo Pereira, I hope I've pronounced it properly, the President of the Bar Association, learned senior advocates and members of the bar, dear students, invitees, members from the press and media, ladies and gentlemen. I must say that I am delighted to be in Goa, which is a state known for its picturesque beauty, and this college, which is also situated very close to the Miramar beach, and the warmth, the lovely sunshine and the hospitality. Getting away from Delhi to be in Goa in winter is really something which every Delhiite wishes for. And I must say that I am now a Delhiite. I'm also delighted to be on a very important and historic occasion as far as VM Salgaocar College of Law is concerned. I thank you all for the invitation and for inviting me to this Golden Jubilee celebrations of the college, established in the year 1973 as the first law college in Goa. It is a pioneer in the field of legal education. I thank the principal, Dr. G. Shabir Ali Ji, and the vice principal, Dr. Kim Kuto, for extending the invitation to the Golden Jubilee celebrations of the college. Colleges such as the VM Salgaocar College of Law, which is a higher education institution devoted to excellence and equity in the legal education, research and training, are critical to a constitutional republic. The college, which was inaugurated in the year 1973 by the revered father of the present chairman of the college, has made remarkable contribution to the constitutional culture and legal profession in the state. We just heard Justice Sonak say that the number of legal luminaries who have passed out from this college, including Justice Sonak. I am impressed that the idea of equality has actually been actualized in this college, since more than 70% of the students, I am informed, are girl students. We heard from Justice Sonak the Belva Lockwood story and the Ruth Bader Ginsburg story and their struggles and successes. Let me tell or address the girl students here at this point to say that there are three aspects. Many girl students or women get into the legal profession, there is no doubt about it, or even the judiciary, but very few get up or reach the higher echelons of the profession or the judiciary. Why is that? The reason is that a woman is conceived to have the responsibility, the pigeonholing of a woman to have the responsibility of the family, which should come above all, over and above her profession, her career. And many a time we have seen that women, soon after their marriage and having children, the women advocates do not return to the profession. There are very few who return, but they return back because they cannot survive in the profession for long. One of the reasons is the pulling of the strings from the home vis-a-vis the children and the family, and at the same time the pulling of the strings from the system and the clients, the nature of work, the long hours, responsibility, uncertain day. You never know how your day goes. In the morning, any lawyer would know. He would get up, get ready, go to the office. He thinks that he has a very good case and the judge is not sitting on that day. It goes to another bench where he would not get relief. Sometimes the lawyer goes to the court and he thinks he has a very bad case, but the judge makes out a point for his case. The way the day proceeds for a lawyer is so uncertain. And within that uncertainty, lawyers have to work day in and day out. The best part of their day is wasted in waiting for courts, for the cases to be called. And they are not able to do much work. But thanks to the technology, they are able to work even in the court with the laptops, etc. You consider how it is for a woman then. She doesn't know how or when she would go back, at what time, if she is a full-fledged advocate. The family is waiting for her. And I sometimes tell that higher the degree of success, greater is the degree of guilt in a woman. But I must say that personally speaking, I'm lucky because I have a very nice family. My husband, Mr. Gopal Krishna, has taken so much of the domestic chores because he has given importance to my work. Not that he doesn't give importance to his work, but he understands that the nature of my work is such that he has to cooperate. And so you all know that they say behind a successful man is a woman, but I would say behind a successful woman is a family. So it is for us women advocates, women students who later become women advocates, how we advocate ourselves with our family to get the best cooperation. That is something which rests in each one of us. With these few words for the girl students, I proceed to once again congratulate the governing body, the principal and staff and students of the college as they embark upon their Golden Jubilee celebrations. 50 years in an individual's life is not so significant. It may be significant for that person, but 50 years in the life of an institution is something of a milestone, because ultimately we human beings, we are mortals, but institutions have a perpetual succession. They are immortal, and it all depends on the future generations to come, the governing councils, the teachers, the faculty, the staff, the students who come year after year in the institution as to how they would carry forward the milestone from year to year. I therefore, while congratulating VM Salgaocar Law College on its milestone of Golden Jubilee, I extend my greetings and good wishes to each one of the persons who are associated with this college, so that the college races ahead from 50 years to 70 years and to the centenary and beyond. I wish the year-long celebrations organized by the college all success. Given the vision and the mission of this college, I thought I'll speak a few words on the theme of transformative constitutionalism, which is a subject not only dear to me, but dear to so many persons who are interested in ensuring that the Constitution is perpetuated in this country. As citizens of a constitutional democracy, we must recognize that our Constitution is not just a document or a legal document establishing institutions of governance. It bears as its core the anti-colonial founding ethos. We must always consider the social, economic, political, and historical background in which the Constitution came and it took its birth. But before expounding further, let me get a little local. I would like to take note of the historical significance of the day, that is yesterday, which marked the 62nd anniversary of freedom from colonial rule for the people of the state of Goa. The transformative character of our Constitution is borne out from the fact that within 9 months, the principle of universal adult franchise was realized for the first time in Goa during municipal and local body elections. Whereas during the colonial rule of Goa, no more than one political party approved by the colonial power was permitted to contest elections. Whereas the transition of power in Goa guaranteed substantive and multi-party democracy. I must say here that multi-party democracy is one of the basic features of our Constitution, and it is only when the multi-party democracy is strengthened that the whole ethos and spirit of democracy would be strengthened not only under the Constitution but in our country as a whole. As I said, the Constitution of India has a profound transformation to our society, our governance. The political change was brought about by two legacies of injustices that prevailed, and the Constitution sought to transform them. The first is the transformation of the legal relationship between the individual and the state after the enforcement of the Constitution on 26th January 1950. It transformed the subjects of the colonial regime to citizens of a country or a republic. It replaced the colonial logic of governing the population with democratic logic of popular sovereignty and public participation. Apart from the universal adult suffrage and structures of parliamentary democracy, the transformation was expressed with a tectonic shift in the constitutional philosophy by having the rights, or the chapter 3, fundamental rights, which is an elaboration of what is there in the preamble of the Constitution. Justice Sonak referred to the preamble of the American Constitution as well as the Indian Constitution, which begins with "We the people." I think our Constitution, when we say "we the people," we mean every person in the landscape of India. It does not exclude anybody. It includes everybody. The preamble itself is so poetic, and therefore the elaboration of the preamble in the rights chapter is what I am going to touch upon briefly. Transformative constitutionalism, even today, seeks to transform social relationships on which legal and political edifices rest. The label transformative actually came up with the South African constitution being inaugurated in the year 1996. One of the American academics, Carl Clare, in his book titled Legal Culture and Transformative Constitutionalism, wrote, and I quote, "Transformative constitutionalism connotes an enterprise of inducting large-scale social change through non-violent political processes grounded in law." I would say that India's struggle for independence, having its hallmark as non-violence, the Satyagraha mode, is the precursor to the constitution, where after independence, in a most non-violent manner, in a most peaceful manner, we have transformed ourselves under the rights chapter, the directive principles of state policy chapter, and the transformation does not end, has not ended, and will never end so long India continues to remain as one integrated country. The goal of a transformative constitution is just not to heal the wounds of the past, but to have a better future. Democratic egalitarianism, recognition and protection of rights, peaceful coexistence and development opportunities are the hallmarks of a transformative constitutionalism. In this regard, I would like to just speak about the interpretation of the constitution as such, the vision that it has, and then proceed to the substantive content of my speech. The constitution is considered to be a living tree. We all know the living tree approach, which has been invoked to justify, for example, the expansive rights of Article 21. It is an evolving document. It is not static. It was not made for only the 50s or the 60s. It will continue to remain so long as all of us are loyal to the said document. Transformative constitution attaches much sanctity to the text of the constitution, its structure, and the historical moment of its framing. While the text, structure, and history are crucial blocks of constitutional meaning, it does not accord an overriding veto to any of them. The framers were so conscious about the words they chose, which expresses principles that would endure. The task of constitutionalism is to identify and express those founding principles that constitute the framework within which constitutional interpretation is to be carried out. Now, we have spoken about the constitution having three different vehicles to carry out the items of its transformative agenda. They are, in simple terms, we say the three organs of the state: the judiciary or the courts, the popular democracy or the legislature, represented through the parliament, and the executive, which is in charge of achieving distributive justice, attainment of independent socio-economic rights, and good governance. The goals of transformative constitution must be reflected in all these three organs as they function in their respective fields. The role of the courts as enablers in this field, I think, is significant. Broadly speaking, there are three themes in the transformation that the Constitution involved. To this audience, I need not stress a lot about it, for they are equality, fraternity, and liberty, which are so poetically mentioned in the preamble of the Constitution. Equality code is contained in Articles 14 to 16 of the Constitution. Gender equality, autonomy as regards sexual orientation, affirmative actions, and reservations are some of the aspects which are strands of transformative constitutionalism in the Equality Code. Equality Code enshrines the vision of substantive equality as opposed to mere formal equality. The second theme is fraternity. In dealing with economic exclusion, social boycotts and religious excommunication, and workplace exploitation, this theme recognizes that liberty and equality are threatened not only by concentrated state power, but also by private orderings that have the potential to block certain individuals' access to the basic goods that are necessary to sustain a dignified life. The principle of fraternity is important not only within the household in a private space, but also outside the household in public space. The third theme is liberty. The Liberty Code is contained in Articles 19 to 22 of the Constitution. The theme explores the transformative goal of the Constitution, which views the state as an enabler of individual freedoms and as vehicles of social transformation. Coming back to the Equality Code, I may say that the transformative constitutionalism envisaged attainment of substantive equality by recognizing and eliminating all forms of discrimination that may have existed or that may come about in future. Recognizing the importance of law reform as a catalyst for social change and the significance of rights in remedying the harsh inequalities of colonial India with its division of class, caste, gender, religion, etc., the Constitution emphasizes the importance of universal human rights, principles of equality and non-discrimination. Because of this very reason, it is because of this very reason that a number of historically exploitative practices have been brought down by progressive social reform movements, legislative developments, and by innovative judicial interpretations. I shall touch upon one or two of such judgments of the Apex Court. Anuj Garg versus Hotel Association of India is important inasmuch as it interpreted Section 30 of the Punjab Excise Act 1914 to hold that it was unconstitutional and anti-woman and against gender justice. There was a provision, that is Section 30 of the Act, Punjab Excise Act 1914, which said that a man under the age of 25 years and any woman in any part of the premises selling intoxicating drug or liquor cannot be enforced. It was contended that it was a very benign provision as far as women are concerned, having right to special protection under Article 15(3) of the Constitution. In that case, you must know Article 15(3) actually states that where affirmative action in favor of women are there, the same cannot be challenged as being discriminatory. But here the contention was the reverse, that in order to protect women who are weak, who have to be protected, who need security, and they cannot work in a place where liquor is sold, and having regard to 15(3) of the Constitution, the provision was constitutional. The Supreme Court was bemused with this argument. The decision in Anuj Garg meant more than just striking down the law. It was for the first time the Supreme Court seriously engaged with the meaning of constitutional imperative contained in Article 15(1), that is, no discrimination on the base of sex. Anuj Garg initiated a jurisprudence whose impact extended far beyond the Punjab Excise Act and which became the foundation for a transformative constitutional vision of gender equality. Recently, last year, sitting with Justice M.R. Shah, I had the occasion to write a separate opinion. Not because I disagreed with Justice M.R. Shah, but I wanted to write the opinion since the provision of law, that is the proviso under the Income Tax Act, to say that a married Sikkimese woman will not have the exemption of payment from payment of income tax, but an individual, that is an individual Sikkimese would have. I wrote because they forgot the fact that an individual would include an individual Sikkimese woman. They did not include Sikkimese woman within the concept of individual, but said that if a Sikkimese woman married outside a non-Sikkimese, then she will lose her exemption to pay an income tax. But on the other hand, if a male Sikkimese married a non-Sikkimese, he would not lose that exemption. So marriage became the basis of discrimination. It could be a basis for classification also, but there it became a basis of discrimination, and particularly when they lost sight of the fact that an individual would encompass a woman. An individual encompasses a woman as much as it encompasses a man or any other gender. So I wrote that, and for the sheer engagement with the concept of gender justice, we struck down that proviso. The decision in Anuj Garg has also brought about the course correction which is necessary in Narges Mirza. I need not go into Narges Mirza, but students of law would have known about that judgment with regard to the air hostesses case, where they had to take permission before getting married. I suppose they had to take permission before getting pregnant also, because if they got pregnant within 4 years of their marriage, they had to give up their employment. So that was the kind of discrimination that was there. But there again, the court at that time in 1981 said, no, it is all in the interest of family planning and it is in the interest of women, and therefore they upheld it. But it requires a course correction. But if you come to the 21st century in Babita Punya and Colonel Nitisha, the Supreme Court has said with regard to women engaged as short service commissioners, they must be given the permanent commission, just like the men are given in the Indian Army. And in Nitisha, they also said with regard to the high threshold that has to be met with regard to the medical tests for getting a permanent commission, there must be a separate parameter for women because of the physiological changes that take place in a woman's body due to the natural process of aging, hormonal activity, pregnancy, etc. And the medical criteria ought to be separate, was what was stated by the Supreme Court. When we come to the directive principles, namely Article 38, 39, 42, etc., it is known that these principles have been there, which are actually an elaboration of the basic human rights and to right a colonial wrong or the ancient wrongs, and the equality that is sought to be established there is on par, whether it is a man or a woman. Moving further in the Equality Code itself, I would say that in Nalsa versus Union of India, the Supreme Court, in its zeal to have the transformative constitutional principle entrenched, stated that decriminalization of homosexuality must be made. There must be a radical reimagination of the constitutional promise that the state shall not deny to any person equality before the law or equal protection of the law. The judgment upheld constitutional morality over social morality and norms to ensure that the lives of citizens belonging to the LGBTQ community are not pushed into obscurity by repressive colonial law, and in which case Justice Chandrachud, the present Chief Justice, as he then was, noted, quote, is an anathema to the constitutional guarantee of equality, liberty and fraternity. Equality, as the Supreme Court reminds us every few years, forbids class legislation but does not forbid reasonable classification. In the context of public employment, we all know Article 16(1) states about the equality of opportunity in matters relating to public employment. Article 62 prohibits discrimination on the ground of religion, race, caste, sex, descent, place of birth, or residence. But Article 64 authorizes the state to make special provisions for reservation in appointment of posts in favor of any backward classes not adequately represented in the services of the state. In the case of Nalsa versus Union of India, in the context of Article 64, the Supreme Court directed reservation for persons belonging to the transgender community in the state employment. So together these cases I discussed are on the basis of gender-based discrimination, equal moral membership, equality in matters of public employment, which reflect the transformative potential of the Constitution's Equality Code. I next state about the second theme, that is fraternity. Fraternity is one of the grand ideals enumerated in the preamble, together with justice, liberty, and equality. While there is little doubt that humankind in general and our country in particular has made gains in the struggle for justice, liberty, and equality, the progress towards fraternity has not been rewarding. Horizontal discrimination, that is, discrimination suffered by private entities at the hands of other private entities within the household, as I said, and outside, proscribed by markers like sex, by constitutionally prescribed markers like sex, race, caste, religion, place of birth, is antithetical to the value of fraternity. Fraternity as a leveling instrument reverses the socialization of biases, discrimination, and power predominance in society, along with liberty and equality. But transformative constitutionalism calls for a realization of full human potential by way of cultivating positive social relationships, and fraternity being the vehicle for achieving this agenda. I think that fraternity is especially significant in order to deepen our democracy and its values. Moving on, liberty is one of the most elementary goals of transformative constitutionalism to maintain and strengthen the principles of our humane constitution. Recognizing the right of liberty is therefore a central nerve to the constitutionalism aspect of our constitution. As a nascent democracy, the Supreme Court had faced several challenges in its initial years in performing its role as the watchful guardian of our democracy. In 1915, A.K. Gopalan was State of Madras. The Supreme Court had the occasion to scrutinize the law governing procedural fairness with reference to the expression procedure established by law in Article 21 of the Constitution. Rather than expanding Article 21, the court narrowly construed it as providing only a guarantee against executive action unsupported by law. However, this underwent a total metamorphosis in Maneka Gandhi versus Union of India, wherein the court took the earlier existing strand of jurisprudence to an expansive ideal and observed that Article 21 would not mark the journey's end in determining whether the procedure adopted by law is fair, just, or reasonable. That a procedure which meets the mandate of Article 21 was still subject to challenge under Articles 14 and 19. This judgment has many proteges to boast and has enabled the creation of right to privacy, right to health, right to healthy environment, amongst others. The Supreme Court assumed a new role as the institutional ombudsman of human rights in India, particularly after the emergency years. The decision in Maneka Gandhi became a starting point, a springboard for a spectacular evolution of the law relating to judicial intervention in various cases. Further, the Supreme Court, speaking through Chief Justice Y.V. Chandrachud, gave enforcement to fundamental rights the momentum it needed to combat state lawlessness in Rudal Shah versus State of Bihar by granting cash compensation to a victim of unlawful incarceration. Subsequent to the decision in Rudal Shah, compensatory relief has been granted in several cases. These judgments demonstrate the sanctity attached to personal liberty and the bouquet of rights associated with it, including the right to bodily integrity, the right to die with dignity, right to reproductive choice, right of self-determination of gender, right to privacy, etc. My next aspect of the presentation is with regard to how public interest litigation as a vehicle has been to secure the Constitution's transformative goals. No discourse on our transformative Constitution would be complete without the reference to transformative jurisprudence or public interest litigation of the Supreme Court and High Courts. Public interest litigation, or PIL as it is called, has thrown open the doors of the courts, particularly the Supreme Court and the High Courts. At PIL is the incarnation of judicial activism in its people-oriented litigative dimension. Under trial as well as convicted prisoners, women in protective custody, children in juvenile institutions, bonded and migrant laborers, unorganized laborers, scheduled castes and tribes, landless agricultural laborers who fall prey to faulty mechanization, slum dwellers and pavement dwellers, kins of victims of extrajudicial executions. These and many more groups now flock to the Supreme Court seeking justice. They come with unusual problems, never before so directly confronted by the Supreme Court. These concerns are to be remedied by rather extraordinary remedies. And sometimes there is a shift in the line, or the so-called Lakshman Rekha, so to say, between adjudication and legislation on the one hand, and administration and adjudication on the other. However, I can confidently conclude that such cases have brought a new debate and dialogue on the transformative potential of the Constitution and the role of the constitutional courts, and particularly the Supreme Court, in a dynamic society such as ours. To this audience, I will briefly touch upon the phases of the PIL, because you would have otherwise studied it. I suppose the faculty is aware of it, the lawyers are aware of it, and the students will study it, but unless I touch upon it, my address would not be complete. The first phase of PIL concerned with conditions in prisons and other places of detention. The focus of the first phase was on exposure of repression by the agencies of the state, notably the police, prison and other custodial agencies. Therefore, the court was looked to as an agency which would enable citizens to combat repression and government lawlessness. The court thereafter concerned itself with questions of social justice, including exploitation of bonded laborers and conditions of work and pay of unorganized workers. Spurred further, the court examined questions of land entitlements of poor peasants and thereafter engaged with environmental law. Human rights of prisoners subjected to torture, victims of police excesses, inmates of protective homes and asylums, and like concerns have drawn remedial attention of the Apex Court through PIL. The next phase promoted recognition and respect for social and economic rights. In People's Union for Civil Liberties, PUCL versus Union of India, the Apex Court did not merely issue directions for conceptualizing and implementing a centrally sponsored poverty and hunger alleviation program, but also appointed an expert committee to monitor the compliance of the court's order within a fixed time. The court expressed its deep anguish regarding the increasing number of starvation deaths and drew critical attention to the inadequate system of food security. The right to food was articulated as a fundamental right for the first time by disregarding the plea of the government concerning lack of resources. We all know that in 2001, the court, in a series of orders, mandated the midday meal scheme to be implemented in schools and the ICDS scheme also to be implemented, which also included immunization, nutrition, and preschool education programs. A prime example of this dynamism is the recognition of the right to food as a part of Article 21 of the Constitution, which in turn prodded the Parliament to enact the National Food Securities Act of 2013. In Olga Tellis versus Bombay Municipal Corporation, the court, speaking through Justice Y.V. Chandrachud, Chief Justice, progressively deciphered the holistic meaning of the term life as appearing in Article 21 to recognize right to livelihood as falling within the umbrella of rights under Article 21. The ambit of livelihood as a concept is no more confined to physical means of living, such as food, shelter, and clothing, but has evolved to include other basic necessities of life like education, medical care, livelihood, etc. Thus, it includes rights to live with human dignity, right to healthy environment, free education up to 14 years of age, emergency medical care, etc. In a series of cases, the Supreme Court has addressed the issue of health care being regarded as fundamental right and has imposed an obligation upon the state to create conditions necessary for good health, including facilities for basic, curative, and preventive health services. We saw how important this was during the COVID-19 pandemic since the years 2020. The right to primary education, being a facet of right to life, made the Parliament to introduce Article 21A of the Constitution in the year 2002 and to enact the Right of Children to Free and Compulsory Education Act 2009. Transformative constitutionalism, qua the right to life and personal liberties, had a tectonic shift in the views of the apex court in Justice K.S. Puttaswamy versus Union of India, as contrasted with its earlier view in ADM Jabalpur. In MC Mehta versus Union of India, the Supreme Court accepted that environmental pollution and industrial hazards were not only potential civil torts but also violations of fundamental rights redressable directly by the apex court through the medium of pill. The apex court has concerned itself with the industries polluting environment by toxic emissions or discharge of hazardous effluents, has banned felling of trees except in accordance with the guidelines, prohibit operation of shrimp culture located in ecologically vulnerable zones, and hence sought to protect natural resources as a custodian and trustee for future generation. The Supreme Court has accepted the sustainable development principle and has applied the polluter pays principle and precautionary principle as part of the environmental law. The Constitution is a transformative document and its transformative vision has several components. As I now said, liberty, equality, fraternity being among such components. Justice is, however, the chariot through which the transformative vision may be secured, and the charioteers are the judiciary, the executive, and the legislature. The judiciary, as highlighted earlier, is required to breathe life into substantive rights and freedoms. The judiciary should not take a back seat or leave it only to the executive or the parliament to come up with certain programs or schemes or rights, but itself must recognize the rights when there is a vacuum in certain areas of life or law. While transformative constitutionalism with regard to its meaning continues to draw debates in the face of various different experiences across the world, a key element that defines transformative constitution is the role of state, including the courts, in fulfilling the project of emancipation and constant development of the ideals of liberty, equality, and fraternity. It is these principles on which the society must sustain, and the state must play an active role in constituting a society based on these principles. I conclude by saying that to interpret the Constitution transformatively, we must understand the people for which it was made and for which it is continuing to apply, that is, the aspirations, the frustrations of the people and the goals that they wish to seek, who are placed at the center of the agenda on the transformative constitutionalism. The tyranny of unfreedoms that restrict growth and development of an individual, such as systemic social deprivation, intolerance, etc., must be uprooted in order to unearth the true transformative potential of Constitution. It is in institutions such as this, the Salgaocar institution, where the Golden Jubilee is being celebrated, the mission of transforming our Constitution for the people by their syllabus and the manner in which they teach, that will lead to the students here to absorb what is required of them when they enter the legal profession, or just be, and even if they don't enter the legal profession, to become enlightened citizens. On that note and hope, I conclude my lecture. I once again thank the organizers for inviting me to deliver this lecture on a very intellectually stimulating theme. I thank you all for your kind attention. I hope I have not tested your patience too much. Thank you and namaskar. Sorry, it has taken a lot of time.
I express my deep sense of gratitude, your leadership for sharing with us your words of wisdom, and for addressing issues and concerns relating to deprived ecology and environment and affirmative action by judiciary and parliament. Thank you. Your leadership's presence has magnified the significance of today's occasion. We shall forever cherish this moment. As a mark of appreciation and respect, I request Mr. Dattaraj Salgaocar, President, Governing Council, Devi Sharwani Education Society, to present a token of gratitude to Honorable Mrs. Justice B.V. Nagarathna, Judge, Supreme Court of India. I also request Mr. Dattaraj Salgaocar to present a token of gratitude to Honorable Shri Justice Mahesh Sonak, Judge High Court of Bombay at Goa. There is one kind of robber whom the law does not strike at, and who steals what is most precious to all of us, and that's time. So it's time to conclude. Well, I request Principal Dr. Shabir Ali to deliver a vote of thanks.
Good evening, all of you. I am honored to stand before this august gathering of legal luminaries to express my gratitude to various dignitaries on the dais as well as off the dais. It's my obligation to display my gratitude in making this event, that is Golden Jubilee celebrations, memorable, unforgettable, and grand success. Without all of you, this program would not have been possible. Thank you one and all. I take this opportunity to thank Honorable Justice Mrs. B.V. Nagarathna Madam, her leadership for accepting our invitation in spite of her busy schedule to grace today's occasion. And Madam was in Bangalore and she came from Bangalore to Goa to grace this occasion. Thank you, Madam, for your kind words, kind advice. Her leadership, you have enlightened us with inspiring words of wisdom. Our students will follow your advice. Thank you, Madam. Our management has been our constant support. Our Sri Dattaraj B. Salgaocar, President, Devi Sharwani Education Society, initiated discussion with her leadership, Supreme Court Judge, for our Golden Jubilee celebrations as a major of our students of the college are female students. I think almost 70% are females in the college. I think Justice Mehta informed that. I think Justice Mahesh informed that there is no discrimination because of majority of students are girl students. But thank you, madam, for this. I think Honorable Justice Mahesh Sonak has taken the initiative to invite her ladyship to Goa for our Golden Jubilee celebrations, and Justice Sonak sir has taken a lot of trouble to and help us in inviting her ladyship, and sir called me around 8 times during festival day, that is Diwali. I don't know how many times sir called just Nagarathna madam for inviting her to come to Goa to grace this occasion. Thank you, sir. Thank you for giving the opportunity to share ideas with Justice Nagarathna madam. District Court and other lower courts, especially Advocate Cyrus Redekar sir, Senior Advocate, Advocate Sujin Salgaocar, Advocate Kolo Pereira, and Advocate Nitin Desai for your presence during this August gathering. The college always and continuously nurtured in all our activities. Big thank you to our President, Dattaraj Sri Dattaraj V. Salgaocar, and his support, his help, cooperation, advice, and approval for all college activities. Without your support, this event would not have been possible, sir. My sincere gratitude to Mrs. Deepthi Salgaocar, Vice President, Governing Council, and Mr. Vikram Salgaocar. Thank you, madam, and thank you, Vikram, for your presence during this Golden Jubilee celebration. Members of Governing Council, Professor Bhaskar Naik sir, Professor Anil Dinghe sir, Professor Gaonkar sir, Advocate Nitin Desai, and Professor Dr. Maulik Ahmed. Thank you for gracing the occasion during these celebrations. Thank you. I think I remember that one of the faculty during one of the program informed that to remember the articles of the Constitution. Students are saying difficult to remember, and sir informed that if you want to see audience making power of the parliament, you have to remember 1, 2, 3. So that time the movie was Teja, 1, 2, 3. Sir's is words saying that remember this, easy for you to remember the Constitution of India. That is none other than Professor Dr. Venkatrao sir, who is the Vice Chancellor of IAULR, for gracing occasion. Thank you, sir. Just I spoke to sir yesterday, and immediately said that yes, I am coming for the program. Thank you, sir. In charge faculty, members of various committees, starting with reception committee, headed by Vice Principal Dr. Kim Koto, Dr. Sonak Desai, Recruitment Committee, Ms. Ashwini Naik and Ms. Ruhi Phate, Press Committee, Mr. Ramrai Naik and Disha Desai and Varsha Redkar. And the Logistic and Arrangements Committee, this hall was arranged by the Logistics Committee. The credit goes to our Administrator, Sri D.P. Pednekar, Dr. K.S. Rao, Dr. Sonak Desai, student volunteers. Without your support and without your cooperation, this hall would not have been possible. Thank you one all for this occasion. And even the presentation made by Dr. Kim with the help of Professor Dr. M.R.K. Prasad regarding 50 years Law College, a journey. Thank you, Dr. Kim and Dr. Professor Prasad. Our system administrator, Ms. Siddhi Raul, for all this IT department, and she headed the IT department, and all we can see the banners, all things, she created all these things. Thank you, Ms. Siddhi Raul. Dear student volunteers, once again, thank you for all the arrangements, all the support involving all the committees. Without your support and without your help, this event would not have been possible. Let me thank PS to her ladyship, Mrs. Nagarathna, Dr. Mukesh Nasa, for their patiently reply from time to time about the arrangements and what is happening about I can say Mrs. Her Ladyship's program to us continuously. And even Registrar of High Court of Bombay at Goa, Mr. Sanil Pillai, the protocol officer, coordinating with us regularly and informing us the update of the event. La Paz Hotel, Vasco for refreshments for this program. A big thank you to each and every person. Sincere thank to all who assembled for today's session. In case I missed any name, it is not intentional. Kindly excuse me. Last, before winding up, let me quote Hindi quote. मैं उठा ये स्वर्ण जयंती समारोह, मैं उठा ये स्वर्ण जयंती समारोह, जब से आप पधारे हैं ऐसा एहसास होता है, जब से आप पधारे हैं ऐसा एहसास होता है, आप हमारा है. Thank you and all.